Okay, so good afternoon. My name is Rosana Garciandia, and I am co-director of the King's College London Centre for International Governance and Dispute Resolution, CIGAD, and also research leader at the British Institute of International and Comparative Law, BIICL, where we are meeting today. Let me also introduce my colleague Pierre Gauci, who is Arthur Bad Senior Research Fellow and Director of Training here at BIICL, with whom I am chairing this discussion. We are delighted to welcome you all at this event, jointly hosted by CIGAD and BIICL. I would like to start by thanking our events teams for making it possible, our speakers who have very busy agendas and have taken the time to join us personally or virtually for the discussion from different parts of the world, and you all for being here either in person or online. We're privileged to have with us a fantastic lineup of experts to explore collective trends in international litigation and also what their implications may be for human rights and for small states in the protection of their interests in areas such as climate change. States are increasingly joining forces in international litigation. We are seeing that. And recent examples of these are, for example, proceedings before the ICJ initiated by Canada and the Netherlands against Syria on torture, or also the unprecedented use of massive third-party intervention in Ukraine by Russia. But these are not the only collective trends that we see. Another collective trend that we consider important to observe in recent litigation cases is that of states standing up against violations of international law that may not affect them or their citizens directly. The world has witnessed, for example, the initiation of proceedings before the ICJ in the case of the Gambia v. Myanmar on genocide against the Rohingya, the case of Canada and the Netherlands v. Syria that I mentioned, or the application by South Africa against Israel on genocide in Gaza. These collective responses could consolidate a new paradigm where the potential of existing mechanisms is revisited to serve coordinated efforts from the international community. And I think exploring these trends is particularly important in a moment when the position of some states towards multilateralism, cooperation, and international law is skeptical, to say the least. Whether there is an actual paradigm shift or this is only a sort of optical illusion or a short-term trend will depend greatly on the outcome of those cases and on future state choices. Be that as it may, those examples of collective spirit could represent an opportunity for small states in their attempts to find avenues to strengthen their position in international dispute settlement and in the protection of their own interests. Equally, those trends may send shockwaves to how states engage in international human rights law, in particular international human rights mechanisms, opening up opportunities for more collective action before UN or regional treaty bodies. So against this background, over the next 90 minutes, we will hear from experts in each of these areas, and we'll engage in discussion with you all about the opportunities arising and the risks that will need to be mitigated. We're already exploring some of the risks in the chit chat before starting this panel. We will do it on the solid basis of a book that we are delighted to launch today. You may have seen it at the entrance, and we have another copy over there. It is this edited volume on interstate communications and human rights, to which many of our speakers contributed their knowledge on a human rights mechanism that is underutilized but has great potential for dispute settlement, for human rights protection, but also for state accountability. The book is published by BIICL, to whom we are very grateful. And it is one of the outcomes of a project on which BIICL and CIGAD have cooperated for the last 3 years, which my colleague Pierre and I lead, and where I'm thrilled to see some familiar faces, some former students, now brilliant professionals contributed throughout the long process. We're thrilled to bring it to you today as a source of inspiration for today's discussion, but also we hope as a reference publication on interstate communications before UN treaty bodies. I will introduce our speakers as they intervene. Each of them will have the floor for approximately 8 minutes. And we will then open the floor to questions. We will have some time for discussion, and Jean-Pierre will wrap up with some concluding remarks. So our first speaker is Nicolas Angelet, Professor of International Law at Universite Libre de Bruxelles, who will be setting the scene on collective trends in international litigation. Thank you, Nicolas.
Thank you very much. Thank you, Rosana and Jean-Pierre, for inviting me, and also for, as you invited me, obliging me at first to look into your book and then being totally absorbed and even more happy than I was before. It's been extremely useful for me in preparing my 8 minutes. Perhaps I should start with an overview of collective action depending on the type of proceedings. It is not a very subtle, well thought of analysis. I'm just going to show a few trends. The first type of collective proceedings that we have, of course, is that of advisory opinions at the ICJ, before the ITLOS, and also before regional human rights courts. Now, if we just concentrate on the ICJ, let me just give you a few numbers. In the Chagos case, there were 43 participants. In the climate change case before the ICJ, 92. In the policies and practices of Israel case, 57. And more recently, in obligations of Israel in relation to the UN and other international organizations, 45. So these are important numbers, but my submission is that the nature of these cases is more important than the numbers. Originally, for decades, the most important advisory opinions were about the institutional law of the United Nations. And they allowed the ICJ to become something like the constitutional court of the UN. The more recent cases, of course, there is always an institutional aspect, but essentially they are about obligations under general international law and mostly about erga omnes rules or peremptory norms. So this also confirms the tendency that Rosana just mentioned. Then we have contentious proceedings brought by not directly affected states. A few examples: Canada and the Netherlands bringing a joint application against Syria. Now, the joint application is something specific and very important, I believe, for purposes of efficiency. And then we have the Gambia versus Myanmar, which was not collective initially, but which is growing as very much a collective action as well. And that comes through third aspect, interventions. Gambia versus Myanmar, we have one joint intervention again, Canada, Denmark, France, Germany, Netherlands, UK. And then we have many other individual interventions. Ukraine versus Russia on the Genocide Convention, one joint intervention, if I'm not mistaken. Canada and the Netherlands seem to come along very well recently. And then we have also others by Austria, Czechia, Finland, Slovenia, etc. 29 in total. And there is South Africa versus Israel. So basically what we see is that, even though I did not show that, because I did not show to you what happened in earlier days, but there is an increase in collective action, in advisory proceedings, in jointly initiated proceedings, in interventions. Now, if we look beyond the numbers, that increase is very important. If we look at what kind of cases have increased and have caused states to take collective action, obviously we have the nature of advisory opinions, as I mentioned, which don't really address institutional aspects, but more general international law. Most of these cases are about erga omnes cases. So as Rosana said, this is about states standing up to defend international law. So the emphasis is on law enforcement or on lawfare, as we would say, trying to set a flag in a broader conflict by using the law as one means to obtain an advantage on the international scene. It is less, I would say, about dispute settlement, which is the original view on international courts and tribunals, peacefully settling disputes by just making a statement on the law and its application. So that is the first point. It's about law enforcement, lawfare, states standing up for international law, rather than about peaceful settlement of disputes. I would say perhaps not only is collective action not so much aimed at dispute settlement, but it might perhaps be prejudicial to peaceful settlement in some instances, because we have blocks standing in front of each other before the ICJ. So this might be a disadvantage for appeasing the conflict through law. That is something that we should consider. So if that is the objective, law enforcement, we should see the means. And there are two means which I also discovered in the contribution by Rosana and Jean-Pierre in the book on collective action. The first possible means of promoting law enforcement by collective action would be through quality. The idea here would be that being together, we would make the debate more richer, more diverse. There would be more ideas popping up, and therefore it is through quality that we would promote a better law enforcement. I haven't studied all the cases which I mentioned, but those which I attended make me believe that this is not the main feature of collective action, unfortunately, perhaps. Not that the individual contributions are not good. Many certainly are excellent, but they are terribly repetitive. And perhaps one or the other contributor to the submissions of this or that state has had a great idea, which is somewhere in the penultimate line of page 355. But if the court has to read 2,000 pages, I didn't count them, the likelihood that that brilliant idea will pop up from the bulk of similar statements is limited. And here I think there are measures to be taken to improve quality. So if it's not quality, then I think it is quantity. It is about volume. And I also find your very nice formula. You said, I believe, to increase sovereign voices or to enhance sovereign voices. And indeed, that is also important. States appear before the ICJ, either in advisory proceedings or when they intervene as parties to a treaty, not only as parties which are subject to the court's jurisdiction, but also as legislators. And so the louder they speak, the more they are, the more convincing is the position that they defend. So that is important indeed, but I see two potential disadvantages, not to say effective disadvantages in some cases. The main disadvantage is that this takes enormous time and energy from the court. At ITLOS, I was there for 2 weeks, so I listened to almost each and every pleading. So 90% is repetitive. really 90% is repetitive. In the meantime, the court loses 2 weeks, or the tribunal loses 2 weeks to deliberate, to go into more detailed issues, etc. So there is a risk there that repetitive pleadings take too much time and energy from the court. And the risk, I think, is twofold. In contentious proceedings, the risk is that it deprives the ICJ, for example, of the time necessary to delve into the facts. I think it is fair to say that the court has made enormous progress in addressing factual issues. It has been fought to do so, but it is not its main area of business. It used to state the law rather than to address facts and details. Facts, in particular in human rights issues, have become extremely complex, and the court needs time to address these issues. That's the first point. The second, which is about how the law is framed, which applies to contentious proceedings, also to advisory proceedings, is the thicker the layer of similar pleadings that we have, the more general the findings of the court are likely to be, because it has heard 50 times more or less the same general story. Instead of having one person addressing Article 5.1 and another one saying, okay, I will go for 5.2, it's the same story. Therefore, statements, findings are more general, which is not just neutral, it is not good for those who want to promote effective enforcement of the law, because the more general the finding of the court is, the broader the possibility for states, which are, as all states are, not absolutely enthusiastic about enforcing international law, they get a broader possibility to say that they are compliant. So specificity is the other potential victim of repetitive similar statements. And therefore, I would say there is enormous potential in collective proceedings, but we really have to discipline them. We have to organize them. We have to coordinate. We have to, now I'm talking as a sales manager, identify quality objectives and then identify the means to achieve them. Thank you.
Thank you very much. Thank you, Nicolas. We'll now move on to one of our speakers on the screen. She's Veronica Botticelli, postdoctoral fellow at Universite degli Studi di Milano, and she will look at the ICJ and the European Court of Human Rights as leading models in these trends. Veronica.
Thank you, Rosana. Good afternoon, everyone, or perhaps good morning or good evening, depending on where you are joining us from. It's such a pleasure to be here, but first let me thank again Rosana and Jean-Pierre for including me in this timely project and for, let's say, pioneering research on interstate human rights communication, which is nowadays more needed than ever. My task for today, as suggested by Rosana, is to draw an overview of both the ICJ and the European Court of Human Rights as leading forums for advancing such type of litigation. Let me just start with a quote from James Crawford, who back in 2018, in the seminal volume From Bilateralism to Community Interest, containing essays in honor of Judge Bruno Sima, somehow anticipated the future insofar as it advanced a far-reaching observation, which I will quote: better to give states standing in court to protect what they perceive as global values than to leave them only with non-judicial means of dispute settlement, whether in the guise of countermeasures or under the rubric of responsibility to protect. This insight connects directly to Article 48 of RCWA, which, as all of us know, allows any state, not just the directly injured one, to bring cases before the ICJ or, generally speaking, to invoke responsibility for alleged breaches of both obligations erga omnes or erga omnes partes. After this affirmation, at first, there were some concerns this would have opened the gate of courts and tribunals for mass interstate litigation, particularly before the ICJ, but Crawford observed that, at least at the time, states had little, if no interest at all, in bringing such cases. Today, however, we are witnessing a totally different scenarios as more and more states are turning to both judicial and quasi-judicial bodies like the ICJ, the European Court on Human Rights, and as we will see in a few minutes, also UN committees such as the one established by the Convention for the Elimination of All Forms of Racial Discrimination. Cases are formally brought to defend shared norms, to interpret them, to apply them, and this is a substitute to political and coercive means of enforcement. This is profoundly reshaping international dispute settlement, both substantive and procedurally, although worries have been expressed to the possibility or risk of interstate courts to act as a forum for strategic litigation, if not abuse of process, alongside a worry according to which the ICJ, for example, is not well equipped to accommodate multilateral interests, also in terms, as Professor Angelet clearly anticipated, of organization of the proceedings and procedure in general. This shift is not just a quantitative shift, it's not just about more cases brought before courts and tribunals, it's also a qualitative transformation, and it's about a new form of collective action. We are witnessing some current trends, especially on a procedural side. As said, states are increasingly joining forces, whether as co-applicants, third-party interveners, or as parties acting on behalf of the broader international community, whatever this laconic expression means, or on behalf of a group of states parties to a multilateral convention. States are also testing new procedural tools, such as, for example, the massive recourse to interim measures, among others. All in all, this collectivization signals a move beyond traditional bilateral disputes toward defending shared principles in domains such as the protection of human rights, climate justice through the advisory opinions, humanitarian law, broadly speaking, and so on and so forth. This is particularly important for small and vulnerable states, especially those without military or economic leverage, perhaps, because international litigation becomes, especially for those states, a primary tool for protection and participation in the global legal order. High-profile examples of such cases have been already mentioned: the Gambia case against Myanmar over the alleged Rohingya genocide, the South Africa proceeding brought against Israel, the connected proceedings brought by Nicaragua against Germany for alleged complicity in genocide, Canada and the Netherlands complaints against Syria on the basis of the Convention Against Torture, Ukraine multiple cases against Russia, the recent Sudan versus United Emirates Arab States, which have been cancelled from the docket. Also, voices have been spread about a tentative case brought by a group of states against Afghanistan under the CEDAW for the protection of women before the ICJ. At least negotiation seems to be in place. Borrowing from the title of a book from Serena Forlati, it seems that the ICJ now serves not only and not especially as an arbitral tribunal, but increasingly as a judicial body for affirming global values. In this sense, collective legal actions enhance both visibility and legitimacy, sending, at least on paper, a strong message that certain human rights or certain fundamental values are not negotiable. Again, for small states, this is important insofar as also procedurally speaking and concretely speaking, collective action spreads legal and financial costs and also turns isolated voices, let's say, into a unified chorus demanding accountability. Turning to the regional level, the European Court of Human Rights also reflects this dynamic, albeit in a slightly different manner, I would say. Interstate cases under Article 33, while still constituting a minority on the court docket vis-à-vis especially individual application, have gained renewed importance, allowing states to safeguard human rights, to document systemic violations, and to uphold the so-called public order of Europe, again, whatever this laconic expression means. The European Court has progressively developed a twofold typology, at least from Cyprus versus Turkey onwards, with diplomatic protection-alike cases on one side, which are basically treated as individual ones with slight differences, and so-called altruistic case, albeit these cases still constitute a minority. For an example of diplomatic protection-alike case, one may think about the Slovenia versus Croatia case. For the altruistic ones, one may think about the so-called Greek cases brought in the late 60s. Nowadays, we are seeing a mixed situation here insofar as cases like Ukraine and the Netherlands versus Russia, for example, which will be adjudged on the merit on the next 9th of July, demonstrate how regional solidarity can be operationalized also to protect victims and to enhance justice. Importantly, procedurally speaking, interstate applications under the Strasbourg system complement rather than replace individual complaints. They are able to proceed hands in hands with individual cases. Alongside, they, of course, constitute a compulsory means of dispute settlement through which states can expose pattern of violation, push systemic remedies, and so on and so forth. Importantly, also strategically, interstate cases do not require the demonstration of the victim status like in the individual cases, and in many instances do not require exhaustion of local remedies, making them more flexible, proactive, and especially useful also for emerging issues like climate-related human rights claim. In this regard, though the European Court has not yet become, and according to me, will never become, a hub for state-led climate litigation, we can imagine that, of course, cases like Klima Seniorinen urge the court to consider state obligations to tackle climate change, but interstate cases can help small climate vulnerable states among the Council of Europe to contribute powerfully by intervening, for example, under Article 36, paragraph 2, to support progressive interpretation, to offer scientific and contextual insights, somehow acting as amici curiae. Looking forward, interstate procedures could be vital in addressing challenges like the alleged mistreatment of Uyghurs in China, Xinjiang region, as I try to argument in the chapter which I authored for the book. In this regard, China's reluctance to engage with formal dispute settlement, like the ICJ, makes accountability difficult on paper, but there are other quasi-judicial mechanisms under the CERD, for example, under the ILO Constitution, which can offer alternative paths. In this regard, also the ICJ advisory jurisdiction could also be strategically deployed, I don't know if I like this term, to build global consensus around egregious violation, even when, such in the case of China, direct jurisdictional routes are blocked because of plenty of reservations to compromissory clauses devolving the jurisdiction to the ICJ. To conclude, collective litigation, while of course challenging, while requiring coordination, coherence, and diplomacy, is beginning to stand as a powerful tool for advancing human rights, confronting global threats, and so on and so forth. For small states in particular, it offers a way to transcend kind of limitation of size and power, acting as norm shapers and defenders of the international legal order as a whole. I thank you.
Thank you very much, Veronica. We're gonna go quickly to our colleague Mary Lorry-White, who is an independent practitioner and joint secretary at the British branch of the International Law Association. We've asked Meryl to share some reflections on states' strategic choices in international litigation. Thank you, Meryl. I will share the slide on the screen.
Thanks, Rosana. Thank you very much for the invitation to speak today, and to the organisers and the chairs. It's a real pleasure to to be here. I've been asked to speak about trends in collective litigation and state strategic choices, which is quite a topic for 8 minutes. So please excuse me if I go fast. And also I'll just raise points for discussion rather than do anything too comprehensive. So firstly, we've been asked to refer to the research that underlay both a special issue and the book that Rosana mentioned. So I'll do a quick summary of some points from that, and then I'll touch on some ideas focused more specifically on collective human rights litigation. The article that I contributed to the special issue was more of a framing piece, so thinking of the range of factors that states consider before deciding to pursue interstate human rights disputes under international law. And the key theme there was a particular focus on conciliation commissions under universal human rights treaties. So as with all strategic decisions, including probably what we all ate for lunch today, there are multiple factors at play, some enabling and some constraining. They can be formal, informal, structural, institutional, psychological, political, economic, and many, many more. And the nature of international law with its foundation in state consent creates a kind of patchwork of substantive obligations and jurisdictional mechanisms, which can open up opportunities but also impose real limitations, and I think are key points when we think about any strategic human rights litigation. This is a flowchart on the slide, which considers some of the key factors in the decision-making process for state-to-state human rights dispute resolution. And I'll just quickly go through them. So firstly, context matters. These interstate human rights disputes will rarely emerge in a vacuum. Individual human rights complaints may be about one single violation, but that's rarely the case for interstate human rights disputes. And the context will influence and is often decisive in the willingness or feasibility of international proceedings. So perhaps this trend that was mentioned earlier about lawfare or law enforcement is inspiring more and more states to consider that context and bring more similar cases. Substantive obligations. Are there relevant legal obligations, and have states consented to their application? If there's no consent or they don't apply, there's of course no basis for a case. What's the nature of the obligation? How are they framed and how are they interpreted by the relevant body? Jurisdiction, of course, also hinges on state consent. Are there any available dispute resolution provisions? If so, which ones, which bodies, and have any preconditions to access been met? There's a lot to say about admissibility, but I think I'll just refer also to the trend that's been already highlighted to invoke doctrines of obligations erga omnes or erga omnes partes, which broaden the category of states which can bring a case. Evidence is key. So the availability and quality of evidence is crucial to the success of international cases. Where does the burden of proof lie? What is the standard before the relevant body in question? And then there are, of course, the logistical questions around gathering and presenting evidence if you want to bring a successful case. Then we have factors like culture, politics, policy, and available resources, which I won't go into because of time reasons, but of course they're key influences on the type of dispute resolution that might be palatable. And strategic evolution. So dispute resolution strategies rarely remain static. They evolve in response to multiple factors: leadership changes, emerging evidence, shifting politics, developments in the law, developments in geopolitics, etc. So that's the overview, and I'll now spend the next few minutes thinking about some of those factors in light of today's topic on collective litigation. First, I'll look at some recent developments, and then I'll look at potential opportunities for further consideration or ideas that may open up other opportunities. I'll just look at 3 points under each category because of time. So in terms of developments, thinking about context, we've spoken about how context can limit human rights litigation and also broaden it. And thinking about collective litigation, where one state acting alone may hesitate to bring a case, a collective approach could perhaps reduce political costs or bring human rights into the legal spotlight where the headline issues may relate to other areas of international law. For example, if there's a particular collective focus on an issue or jurisdiction to think about a particular issue, that may be the point that comes out rather than the broader contextual points. A good example is the growing litigation around climate change and environmental degradation. These cases, many of which invoke human rights, and I know we're about to hear about these in more depth in a minute, they demonstrate how urgency can drive innovation and how human rights can be propelled as part of that. And we're sort of therefore seeing the development of human rights protections as part of a broader focus on international climate and environmental law. The second point is to think about substance and jurisdiction. So we've seen an increase in creative engagement with different international procedures that overcome substantive and jurisdictional hurdles. We've heard a lot about advisory opinion requests, and this is just one such example. So before the ICJ, for example, the General Assembly and Security Council can request an opinion on any legal question. That overcomes some of the limitations on legal scope that might occur if you're just looking for an avenue for contentious jurisdiction with the limits of state consent. Advisory jurisdiction is, of course, distinct. It concerns legal questions, it does not result in binding decisions, and cannot necessarily be requested by states depending on the international body. But it can open up broad participation, and we've heard, again, already the stats today on a great willingness to participate. So again, these are kind of points that all go into the strategic decision. They're probably therefore going to be part of a litigation strategy that seeks to develop the law or understand better its application in a specific scenario, or the term used earlier today, law enforcement. And then there are other examples of creative legal engagement, including third-party interventions and erga omnes partes invocations that we've already heard about. And then the third point, the third development, is really about evidence. So we've seen an innovation in collective approaches to evidence development for litigation and international accountability efforts. And just to mention one example, that would be the IIIM for Syria, established by the General Assembly, which has supported national prosecutions, including the wave of universal jurisdiction cases in Germany. And in the human rights sphere, where gathering and preserving evidence can be particularly challenging, state secrecy, fear of reprisals, re-traumatization risk, and lack of access to affected areas, for example, can affect evidence gathering. Coordination can be particularly important, especially when we think about the importance of evidence in successful cases. So I'll just close with 3 reflections to provoke further discussion on potential opportunities. And again, I apologize for the speed at which I'm going through these things. Collectivities. So when we're thinking about the collective, perhaps instead of thinking about the collective of states, we can think about the collective of international bodies. We're seeing multiple jurisdictions being invoked in relation to the same issue. For example, if we think about the plight of the Rohingya, that's being considered by the ICC OTP, the ICJ, and universal jurisdiction cases, using different jurisdictional perspectives, but concerning a similar issues, and the climate change advisory opinions across 3 courts, of course. So subject to admissibility conditions, are there potential advantages to parallel proceedings, especially if we're thinking about this law enforcement angle that Nicolas mentioned? And we've seen this already happen before, but could conciliation commissions be part of this collective approach? Thinking of conciliation and the inevitable invocation of human rights in various proceedings focused on climate change, what might the recourse to conciliation envisaged under Article 14 of the UNFCCC and Article 24 of the Paris Agreement offer in this context? Could it offer a path for coordinated state action in addition to other proceedings? There has been a high-level panel convened by BIICL that's worked on a draft conciliation annex, which has been commented on by multiple experts and stakeholders and is receiving input from states. So this is just one such idea for a tool that could be used to strengthen collective approaches. And then very final point is on strategic litigation. So we've long seen collective human rights litigation on behalf of individuals and groups in multiple fora, thinking about strategic shifts in human rights policies, legislation across countries, regions, etc. They're fascinating and humbling cases to work on, actually, and are often coordinated with engagements with human rights holders, domestic court actions, NGOs, campaigns, etc. And I was thinking about this because in a case I recently worked on about sexual and reproductive rights before one UN treaty body, but against several states on behalf of multiple individuals, we saw a significant shift in the interpretation of the Human Rights Treaty for all states parties. So what can collective state efforts learn practically from these experiences? And might strategic litigation of this nature be part of a broader collective effort, as has been the case with climate change? Thank you.
Thank you very much, Meryl, also for sticking to the time and for those very interesting and thought-provoking reflections. We'll now move on to look more specifically at climate change related issues. So this is a nice and organic transition. Margaretha Wewerinke-Singh, Associate Professor of Sustainability Law at the University of Amsterdam, will look at the implications of these collective trends for small states in the context of climate change. Margaretha.
Thank you very much, Rosana, and warm greetings to everyone over there in London and online. So I speak this afternoon in my personal capacity, but of course I'm able to draw on my experience serving as counsel to Vanuatu in the ITLOS, ICJ, and Inter-American advisory proceedings on climate change, and I've also had the privilege of advising the Organization for African, Caribbean, and Pacific States before the ICJ in these proceedings. So for these states that I mentioned, climate change is very much already a reality. So we see that a single cyclone can erase a year or multiple of GDP for these states, not to mention non-economic losses. So for them, climate litigation is really not an academic exercise, but it's fair to say that it's a survival strategy. So my brief remarks therefore focus on what the recent collectivization of proceedings mean for small states, and especially small and developing states, or SIDS, that lack the economic, diplomatic, and technical resources usually needed to litigate alone. So the first point is descriptive. Over the past 13 months, approximately, 3 advisory opinion dockets have been dominated by multi-state alliances. Of course, we all know last year in May, the ITLOS was the first to answer an advisory opinion requests submitted to it by COSIS, and in its opinion, it spelled out concrete due diligence duties to cut greenhouse gas emissions under UNCLOS. And small states not only initiated the request, but also helped shape the hearing schedule. They fixed the bulk of the scientific material submitted in these proceedings, and supplied many of the advocates who drafted submissions and appeared before the tribunal. Just 14 months earlier, in March 2023, Vanuatu marshaled 132 co-sponsors, an unprecedented cross-regional bloc, to secure the adoption of General Assembly Resolution 77-76, of course adopted by consensus, and initiating the advisory proceedings on climate change now pending before the ICJ. Nicolas already mentioned numbers. When we look at regional representation, it's worth noting that every Pacific Island Forum member, almost every Caribbean community member, and a considerable number of small African states filed written statements and comments and/or appeared before the court during the oral proceedings. So these proceedings took place last year in December, as we know, and ultimately 99 states and organizations addressed the court on the legal questions. Then the Inter-American Court of Human Rights also playing a key role, following Chile and Colombia's January 2023 advisory opinion request on climate change. In these proceedings, more than 250 submissions have been made, many from Central American and Caribbean microstates that have never previously appeared in proceedings before the court. So taken together, these three proceedings demonstrate that collective action is no longer an anomaly. It may be becoming the default technique through which CIGAD engage with international adjudicatory bodies on climate change, at least. So why does this matter? First, because collectivization neutralizes structural power asymmetries that are particularly problematic when it comes to attempts to address the climate crisis. So international climate negotiations tend to reproduce the diplomatic weight of the G20 ultimately, and litigation, by contrast, is governed by procedural equality. When microstates act in concert, whether it is through COSIS, through the Alliance of Small Island States, the OACPS, or ad hoc coalitions, they convert numerical vulnerability into majoritarian legitimacy. So the moral force of a dozen endangered states speaking together may compel tribunals to apply the law to the facts in the most conscientious of ways with broad implications. So the ITLO's opinions articulation of a science-aligned obligation of states to essentially take mitigation action based on a stringent standard of due diligence illustrates this dynamic. So the language advanced by CITES themselves now shapes the interpretation of UNCLOS for its 168 state parties. And then second, collectivization, and as mentioned, it reduces the fiscal and technical cost of complex litigation. So COSIS, for example, provides a standing secretariat and a committee of legal experts with several subcommittees that can pool scientific experts, that can draft shared pleadings and draw in various forms of support. So thereby lowering the entry barrier for micro jurisdictions with 2 or 3 person attorney general chambers. And comparable resource sharing models are beginning to emerge in Africa and the Caribbean. So by analogy with the co-authorship practices highlighted in the special issue, these arrangements distribute litigation risks while maximizing their doctrinal impact. And then thirdly, collective filings create a platform for human rights-centered climate narratives that can flow back into domestic courts and treaty body procedures, amongst other forums. So we are seeing small states relying on universal and regional human rights norms and instruments. So invoking the right to health, to life, to culture, to a healthy environment, to self-determination, all to frame climate harm. And even the ITLO's opinion explicitly linked environmental degradation to the enjoyment of human rights of coastal populations, and something that regional tribunals such as the Inter-American Court, and also probably in the near future the African Court of Human and People's Rights, are now likely to develop further. So that jurisprudential cross-fertilization strengthens the hand of local litigants also from small states who may be seeking constitutional remedies or loss and damage compensation in other forums. Now, of course, collectivization is not a silver bullet. As the ICJ and ITLO's proceedings in particular showed, major emitters are arguing that multilateral climate treaties already exhaust the fields that tougher obligations would unfairly target their economic models, etc. And retaliatory trade or aid measures remain a live concern for aid-dependent SIDS. Collective structures can also mask internal disagreements, for example, over the appropriate baseline for emission reductions or over the prioritization of adaptation finance versus loss and damage reparations, to mention just two potential difficult questions. And of course, advisory opinions also are formally non-binding. So without coordinated follow-up through UNJ resolutions, for example, when it comes to the ICJ opinion, through engagement with treaty bodies, domestic implementation, using outcomes in the climate negotiations. If that doesn't happen, then the normative gains may evaporate. That's a strong term, but at least they may not, perhaps not be as strong as we would like them to be. What then might small states and their supporters in these battles, so to say, what might they do next? Well, as a starting point, they will likely maintain and deepen standing coalitions such as COSIS, which helps not only brings the advantages that I just mentioned, but it also helps to insulate litigation strategy from electoral cycles and other sorts of pressures. And then secondly, they could integrate human rights fora more deliberately into climate-related disputes and strategies, engaging treaty bodies with low cost and high visibility. They could embed a more diverse range of evidence in filings, continuing the practice of merging scientific assessments such as IPCC reports with testimonies from local knowledge holders. This much more can be said about this, but I do think that this particular evidentiary architecture is particularly persuasive and can help to bridge the gap otherwise between the law and very technical climate science. And then fourthly, anticipating enforcement. So SIDS, of course, are already thinking about how advisory proceeding outcomes can be brought in line with existing financing mechanisms and other structures that can help to translate legal findings into concrete finance flows. Very important for these small states. Let me close then on a more personal note. When Vanuatu resolved in over time, we often pin the moment down as happening in 2019 to pursue an ICJ advisory opinion. Skeptics predicted that such a tiny state could neither quarrel majority in the General Assembly nor achieve a meaningful outcome at the ICJ in The Hague. Now, 4 years on, the docket of climate-related interstate litigation, so to say, is the most crowded in the history of public international law, and small states stand at its center. So collectivization has amplified voices that were once confined to protest at the margins of COP's halls and climate negotiations. It offers no guarantee of justice, but it does provide small states with doctrinal clarity, with political leverage, and a credible pathway to remedies that match the scale of the climate emergency, in contrast with, of course, what is on offer, so to say, in the negotiations at present. So our task now is to consolidate those gains through different pathways, which may include regional human rights systems, treaty body communications, and strategic test cases, so that the law we are making together becomes a lived reality for the communities we represent. Thank you.
Thank you very much, Margaretha. Also, for that note, reflecting on how those mechanisms can allow climate narratives to flow in different ways. And on that note, I would like to pass the floor to Aaron Stoker. Aaron is attorney and consultant in international law and is a lecturer of international environmental law at Columbia University. And also based on your experience, Aaron, we've asked him to share some reflections on the challenges and opportunities of those trends in small states, strategic choices in dispute settlement more generally. Thank you, Aaron.
Thank you, Rosana, and thank you also to Jean-Pierre for inviting me to contribute to this volume and now a book. So thank you very much for that, and thanks for having me today. In the book, I wrote about the potential of interstate conciliation can play with respect to upholding human rights obligations, but as mentioned today, I'll focus on a different set of opportunities and challenges, particularly those related to collective litigation by small states. In terms of opportunity, we've already heard about the increasing trend that states, including small states and those with lesser means, can act together to pool resources, whether in joint filing, intervention, participation in advisory opinions. It has a quantitative impact, as Nicolas mentioned, reduces political costs, and I won't repeat all of those. As for challenges, there are a few, and they don't necessarily outweigh the opportunities, but acknowledging them is important, and I'll mention a few from the perspective of a practitioner, and some of these interact with the considerations that Meryl eloquently described. First, certain litigation endeavors, or almost all of them, if not all of them, are still costly, even for small states working together. And even if outside funding can be secured for lawyers, or the work is pro bono, litigation demands internal resources within the government as well. So that's time, money, attention, people, or manpower. If, for example, the Attorney General is spending time on interstate litigation, they're not spending time on other things. And lack of capacity for small states in particular is not easily overcome. And outsourcing that capacity, we have to acknowledge, does not encourage long-term internal capacity building. And therefore, collective action, while trending, I do think has its challenges and may only go so far, in the sense that we shouldn't expect small states to be central actors, or at least as central as other states, in proceedings that do not concern their direct interests, like climate change, including in cases related to human rights violations, because of the resources and attention needed. And that does not necessarily change because of collective action, although it could be slightly mitigated. Second, a key question that states need to ask themselves before taking collective action is, do they actually have common interests? Now, dare I say that even when it comes to climate change, not all small states and not even all small island states have the same national interests. And while, of course, Vanuatu did present its oral intervention together with the Melanesian Spearhead Group before the ICJ, there was plenty of coordination going on behind the scenes. Mind you, the only states that filed jointly and presented jointly were the Nordics. The issue of common interest is both substantive on the international level and also domestic. And I'll explain what I mean. On the substantive side, different national interest reviews can exist on global, regional, or bilateral issues. For example, with respect to current hot topics, a global one such as deep seabed mining, or more bilateral disputes such as Israel-Palestine. To assume that all small states all share the same interests because they are small states is, of course, an overstatement or an overgeneralization. And at least for outsiders such as myself, we should be careful not to erase their individual attributes and only see them through that one-dimensional lens. As for the domestic aspect, what I mean is that when a state appears before an international court and tribunal, it's addressing the court, but also messaging its constituents, the viewers at home, and that's especially, of course, true for public hearings, such as the oral hearings before the ICJ. And how you use your limited time takes both of those factors into account. My own personal impression from the climate proceedings before the ICJ is that for many states, that balance of intervention was focused on domestic audiences rather than assisting the court in its reaching its reply to the advisory opinion. And that's perfectly fine. But what this means for our purposes is that having a collective submission or even certain collective positions may be more difficult because then it's more difficult to accentuate particular messaging for domestic audiences in each individual state, thus adding to the challenge of coordination and cooperation. And third, as counsel, part of our role is to advise when advising a small state, and when it's in its interest to intervene, participate in an advisory opinion, initiate litigation, and so on. That's obviously part of the job. And I think sometimes the answer is no. Other than the resources involved, litigation is a legal process, but it's a political choice or strategic choice, whatever word you prefer to use. And there can be, of course, political ramifications that outweigh the interests of acting individually or collectively with others. On one final note, and I did my best to keep it short, some of the biggest issues facing small, particularly small island states are bilateral. And here I'm thinking of an example like maritime delimitation. But even here, one should notice that in certain situations when there are, for example, 3 states involved, 2 of them being small states and 1 more powerful state in the case of a trilateral maritime boundary or another trilateral dispute, the 2 small states can, on some level, cooperate when they have common interests to counter that imbalance. And so even there in the more classic dispute settlement, there could be opportunities for collaboration and coordination for small states. And I'll leave it there.
Thank you very much, Aaron. That's really helpful also from the practical perspective, bringing all these ideas down to the feasibility and the reality that we need to work through. We're going to go back to the room now for David King's intervention. He's Associate Professor in Law at Dublin City University, and we've asked him to talk us through some of the potential implications of collective trends for the protection of human rights. Thank you.
Thanks, Rosana. Thanks, Jean-Pierre. Pleasure to be here. Thank you for the invitation and, of course, for contributing to the collection and now book. So delighted to be part of that. In general, I'll just be speaking on human rights, but I'll be focused on the International Convention on the Elimination of Racial Discrimination, or CIRD, certainly part of collective trends. So I'm just going to look a little bit at the case law that has arisen under CIRD and maybe reach some conclusions also going forward. I think just to point out that the international human rights treaties have been sort of unevenly drafted. So some lack a compromissory clause like the ICCPR and ICESCR. Some lack an interstate communications mechanism before the UN treaty body like CIGAD. CIRD has both, not only has it both, but it's also got the only compulsory interstate mechanism under Article 11. It has had the only interstate communications or cases before a UN treaty body, and it has been the only completed case before a UN treaty body as well, which was Palestine versus Israel last August. There have been 8 cases in total taken under CIRD, most of them relatively recently, 5 before the ICJ and 3 before CIRD, as mentioned, all decided except 2, which is the Armenia-Azerbaijan cases, which there's been some reports might be discontinued. So we'll see on that before the ECH or before the ICJ, but they're presently the only 2 not decided. But it certainly seems opportune to reflect on interstate case law under CIRD overall. So there's Nagorno-Karabakh, which I'll come back to. Firstly, a number of things have been determined, I think, over the course of the 8 cases. The relationship between CIRD and the ICJ. Article 11 is the interstate communication clause. If the state party considers another state party not giving effect to the provisions of the convention, it is of course open to any state party to bring any other, and there are 182 states parties to CERD. So that's a very wide-reaching, near universal contentious jurisdiction, really the only universal contentious jurisdiction of this kind under any treaty. Article 22 is the compromissory clause before the ICJ. It was established in the first case, Georgia versus Russia, that there were preconditions. It was established in Ukraine versus Russia that the preconditions are alternative. The two preconditions are negotiation or the CERD interstate mechanism. And once the ICJ decided they were alternative, that meant that disputing states can go directly to the ICJ under Article 22 if they negotiate in terms of the convention. So the result of that, whatever about the law of it, but the result of it is that states are unlikely to go before CERD if they can go before the ICJ. So any future case law before CERD is likely only to involve the 25 states parties to CERD which have a reservation. Judge Tomka pointed out in the Ukraine case, this is tantamount to holding that states anticipated 11 to 13 to serve as a residual mechanism against states which make reservations to Article 22. Nothing suggests this was the intention of states when they negotiated the text of the future convention. So whatever the intention of the states were, that is the result. And so that was decided in Ukraine v. Russia, and the Armenia-Azerbaijan cases happened after that, and certainly sort of bore that out, as it were, because Armenia and Azerbaijan didn't go before the CERD committee, but went directly to the ICJ, having negotiated and satisfied the preconditions. So what we're left with for future interstate communications before CERD, although this is not definite, but certainly seems likely that it may involve one of these 25 states. I just gave the list of them there. As you can see, of the 3 CERD communications that happened, 2 of them are on this list, Israel and Saudi Arabia. So they both had a reservation, which meant you could not bring either of them to the ICJ. So it's not, I think, a sort of they could only be decided under before the CERD committee. United Arab Emirates, I will come to, which is the only case where was brought before the CERD committee, but could also be brought before the ICJ. But Qatar, of course, went to both. It was highlighted by Veronica Botticelli, I think, in terms of potential. She mentioned, for example, the situation involving the Uyghurs, China. So China is one of the reserving states. You can't bring China under CERD before the ICJ. You could bring China before the CERD committee. What state would do that, I think, is another question, but certainly as a compulsory interstate mechanism, that is, I think, the only sort of forum you could bring that question before in a contentious case. China has not ratified the ICCPR. China has ratified CERD. CERD has held that the Uyghurs are a group protected by the convention. CERD has issued concluding observations on that question and has even used its innovative early warning and urgent action mechanism in relation to the situation in Xinjiang, which points out the collective character of the convention in relation to erga omnes obligations. Case law involving both the CERD committee and the ICJ has led to some, I think, conflict. That is pretty starkly illustrated in the Qatar versus United Arab Emirates cases, one of which decided by the CERD committee, one decided by the ICJ, with 2 completely conflicting results. It was about the scope of the convention, whether national origin in Article 1.1 includes nationality, includes Qataris. The case involved, inter alia, the expulsion of Qataris from United Arab Emirates. Qatar argued that was a violation of CERD. Emirates argued that this did not come under the scope of the convention, that Qataris as a group are not protected by the convention. So CERD decided it and decided that they do come under the convention, and the ICJ decided that they do not. Now, I'm in favor of CERD's decision. I'm a CERD scholar. I think CERD's decision is the correct one. I don't like using the word correct and incorrect, but if you look at the convention very briefly, I mean, national origin is there. There are 2 exceptions in Article 1.2. Convention shall not apply to distinctions between citizens and non-citizens. Nothing in the convention can be interpreted as affecting the legal provisions of states parties concerning nationality, citizenship, or naturalization, provided such provisions do not discriminate against any particular nationality. So in my view, the expulsion of Qataris does discriminate against a particular nationality and is a breach of Article 1.3. Now, we never got there in relation to the ICJ. I think the setup of Article 1 is fairly clear that distinctions between citizens and non-citizens or based on nationality can come under the scope of Article 1, but there are exceptions in 1.2 and 1.3. The exceptions indicating that they can be read into Article 1, paragraph 1. CERD made this pretty clear in General Recommendation 30. Differential treatment based on citizenship or immigration status will constitute discrimination if the criteria for such differentiation judged in light of the object and purpose of the convention are not applied pursuant to a legitimate aim, are not proportional to the achievement of this aim. So ordinary distinctions, border controls, etc., are clearly not a violation of CIRD. On the other hand, if your distinctions such as expulsion of a particular nationality, what exactly is the legitimate aim of that? And is that a proportionate response? So if not, then it would be in breach as such of Article 1 as understood by CIRD under General Recommendation 30. The ICJ differed in its opinion. There were dissenting views. Judges Bandari and Robinson more or less sided with CIRD in terms of its reasoning, the legal reasoning, and also pointed out that the ICJ itself is supposed to attach great weight to the pronouncements of UN treaty bodies, although it had said that in relation to the ICCPR, it has not said that. It said that in relation to the ICCPR and did sort of repeat that line as well in relation to Qatar, but then found otherwise. So those conflicts, I think that conflict is pretty stark. The other aspect, I think, in relation to CIRD and the ICJ case law is the extent to which what you might call backlash should be the wrong word, but certainly when the Armenia and Azerbaijan cases happened, and they happened more or less at the same time, there was sort of a feeling criticism of the use of CIRD. We get phrases like the certification of conflict coming out in blog pieces, that CIRD is being used to sort of shoehorn issues that don't belong under a treaty on racial discrimination, wider issues of conflict. It's a device to get your issues before the court. This is not a sort of a new argument, but it became, I think, pronounced because the number of cases that come before CIRD. Judge Yusuf's dissent in the provisional measures in relation to cultural heritage very much captured that, throwing open the gates of the convention to all kinds of claims, transforming the convention into a four-two, which is sort of a French phrase for a hold-all, into which all sorts of rights may be stuffed. So my piece, I think my contribution in the book was really about that issue. I just looked at the dissent in detail. Is he right? And sort of there were a number of points to the argument. First of all, that CIRD relates to human beings and not objects, and therefore doesn't relate to cultural heritage. Doesn't apply to monuments, doesn't apply to sites. Second of all, that doesn't apply to religious monuments, destruction of a cathedral, for example, in Nagorno-Karabakh being part of Armenia's claim. And third of all, that other instruments cover this, in particular the UNESCO conventions protecting cultural heritage and armed conflict and other instruments like that. So I very much disagreed with the opinion. When I find it sort of surprising that such a strong opinion will come out without any reference to what you might call the CIRD archive. CIRD has been interpreting the treaty since 1970, so we have 50 years of CIRD practice in relation to cultural heritage. And when I went back, I found the first references in the early 70s in relation to Peru and indigenous peoples, in relation to China on measures to protect Tibetan cultural heritage, 1983, Pakistan preserving the cultural heritage of pre-Islamic civilizations, again from the 1980s, Guatemala, indigenous communities to be protected, including their physical existence and cultural heritage from the 1990s. States themselves reported to the committee on how they're protecting cultural heritage, different groups. Colombia is a multiracial society, defends the cultural heritage of all indigenous communities. Australia informing the committee about Aboriginal cultural heritage, essential to get remains returned from museums around the world. And Mauritius describing there how that's Lemourne, the cultural heritage site, where a symbol of symbolizing the resistance of runaway slaves is a national, regional, and international memorial site. Also sites for indentured workers from India that arrived in Mauritius as well. CIRD also involved an early warning mechanism, which it consistently uses in relation to cultural heritage sites in extreme danger, such as in the Philippines, the destruction of a particular mountain sacred to the Subanon community, or in Chile, the destruction of sacred sites, again, in national parks. And religious cultural heritage also, I mean, the convention itself came about because of the destruction of Jewish cultural heritage, what was known as the swastika epidemic in the early 1959 to 1960. And the committee has consistently reacted to the destruction of synagogues, desecration of cemeteries, and other aspects like that. So even the very sort of genesis of the convention was around protecting cultural heritage of groups as well as the individuals themselves. The committee has never been able to sort of disentangle those things. And we see it in more recent concluding observations or activities, preservation of places of worship in Xinjiang and in Tibet in relation to China and the Afro-Brazilian religions, which have been particularly attacked in Brazil. And CIRD has sort of reacted to that and argued also in terms of remedies that the state must rebuild destroyed religious sites. So we see that very strong sort of emphasis come through in CERD practice, not necessarily represented in the ICJ dissent, which seemed to gain quite a lot of traction. One final point made on this was Judge Youssef also referenced ECHR, so we're getting sort of ICJ case law on CERD, referring to decisions of the ECHR. Again, I think slightly bypassing CERD, but there it is. The Ahanbey decision of the European Court of Human Rights, where the court didn't decide that cultural heritage came under the scope of the convention. I think Ahanbey is a very poor decision of the European Court of Human Rights, and it did result in the destruction of Hasankeyf, which is there in southeast Turkey. There were questions of standing. The complaint wasn't brought by members of the Kurdish community who were directly affected. Similarly, the European Court did say that cultural heritage and human rights law relates to minorities, indigenous peoples, who are, of course, directly protected by the CERD Convention and not necessarily exactly by the ECHR. So they're very different treaties. The decision of one does not necessarily apply to the other. And it also highlighted the gaps in UNESCO regime. In other words, what human rights treaties provide in this area is a means of compelling states to appear before them where cultural heritage is endangered, and that's lacking from some of the dispute resolution mechanisms before or under the UNESCO treaties. Okay, in terms of time, in terms of conclusions, on the cultural heritage question, I think CERD clearly does protect convention groups, both in peacetime and in armed conflict. I don't really have time to go into CERD and armed conflict, but in my view, and again, the practice of the committee is that it clearly applicable in armed conflict. You can put it under a sort of a text, context, object and purpose formula. That is very important to any ICJ determinations. CERD overall has traveled from the margins of human rights law to the center of the hottest interstate lawfare. That's according to Professor Catherine Costello. I think that's fair to say. It has, the interstate case law has given CERD a sort of a platform that perhaps wasn't there before. On the other hand, human rights violations viewed from an interstate perspective can only bring to the fore very limited aspects of these problems, and I think that's true as well. So only a sort of handful of issues have come up in interstate disputes, and the most far-reaching protections of cultural heritage under CERD are likely to come under state reporting or individual cases, or indeed the early warning urgent action procedure. I close with just one very final point, which is that all of the cases I've discussed, or issues I discussed, have been raised under Article 11 or Article 22, but we're seeing CERD emerge also in the advisory opinions much more forcefully. If you contrast, for example, the Wall advisory opinion from 2004, the human rights treaties there, the ICCPR, ICESCR and CRC, and CERD is not mentioned, which is surprising when you consider the Wall relates to issues of segregation, etc. 20 years later, in the more recent advisory opinion, the Wall, or CERD is central to the ICJ's findings. And similarly, Nicaragua versus Germany, a case not mentioned, raises CERD also. So we're seeing CERD become much more prominent, I think, in other sort of collective actions as well. I did for time, but I'll leave it there. Thanks.
Thank you very much, David. And on this note, we will turn back to the screen for our two final panelists. First, Frans Viljoen, Professor of International Human Rights Law at University of Pretoria, who will have a closer look at the African regional human rights system and the implications in that context. Thank you, Frans.
Thank you. Thank you very much also for the opportunity. Really doing the book project with you was an eye-opening experience. I think there was very little attention to interstate collective state involvement in litigation up to that point. So for me personally, it was also a very rewarding and insightful experience. So my mission is to just very briefly give you a sense of how the issues that we discuss relate, I suppose, to the African context, to just do a dip and see where that leaves us. If you will allow, I will try to share my screen. And is that visible to us? Yes. So first of all, I thought when we talk about collective litigation, the African Charter system is well known. One of the major features of the African system is that it contains collective rights, the rights of peoples. But obviously that pertains, the African Commission and Court has also said not to states, but to individuals and groups. But in its interpretation of what a people consist of, the institutions have said that it has a dimension. It can consist of everyone in the nation state, all the people in the state, or it could be sub-national groups like minority groups or indigenous peoples. But I think what the topic at hand invites us to do is to think about how the understanding of peoples can also have a transnational dimension. So if we see the interest of peoples as an interest that is shared by more than one nation state, and that also I think feeds back into the idea that colonial borders are kind of artificially imposed on Africa. It's really the people that are often also dispersed across borders. So I think in this context, what is called for is also thinking of what African peoples are, not just as those that comprise the nation state, but those across borders, and also even a Pan-African notion of African people, that we could instrumentalize that within the African Charter. But as far as African states are concerned, I think the idea of solidarity is also very key to the African Charter, and I think animates our discussion here. Obviously, the interstate mechanism is the main way in which we would then see that states would act on behalf of the collective, the people that they represent. And in these few cases, we see that the states would generally invoke the human rights to a collective, to the people, that is the basis for an interstate complaint. We have three bodies, as many of you would know, in the African system: a commission, our African Court on Human Rights, and also a committee. And each of them has a competence to deal with interstate complaints. It was mentioned before that under CIRD there is the compulsory interstate complaints mechanism. That is also true of the African Charter, remarkably. Under the African Commission, all states are open to be sued and can sue in terms of interstate complaints. There's no optional mechanism. That applies also to the Committee on the Rights of the Child. However, for the court, obviously, it depends on the jurisdiction of the court being accepted. So very briefly stated, under the Commission, we've only seen 3 cases ever being brought and 1 case decided. That was a case of the Great Lakes area, the Democratic Republic of Congo, against its neighbors, Burundi, Rwanda, and Uganda. And that was decided in 2003. What is interesting is that the case was not revealed, was not made public until a few years later, because there was a similar case pending before the ICJ. It ended up DRC versus Uganda, and it also showed a certain sense of reticence on the part of the Commission to conclude this case and defer, if you like, almost to the decision of the ICJ before actually this was publicized. The African Court has thus far received 1 interstate case. And actually, by the time the project started, this case did not exist. So it really came, as you could see, it was in 2023. And interestingly, on Thursday this week, the court will hand down its judgment on the preliminary issues. We are still at the stage where admissibility and jurisdiction are being contested. I have all, I think, hope that the matter of the preliminary objections will be dismissed and the matter will proceed to the merits decision. I mean, there were issues raised around, for example, the political nature of this case by Rwanda, the abuse of process, because there was also a case submitted before the East African Court of Justice. There were issues raised about extraterritorial application, but I think most of these were relatively frivolous and not based on the legal instruments at hand. So one can conclude from this that the African states have been quite reluctant to use the interstate complaints mechanism, even if it was clearly at their disposal, and to just contemplate on some of the reasons. In Africa, just as in many parts of the world, there's a preference for a kind of a more conciliatory approach. There's a lack of litigation, generally speaking, at the national level, at the international level. There is also, I think, this one precedent that the African Commission has presented that did not inspire much confidence. But back to the idea of peoples, there's also the notion that because peoples, in other words, even the people within the state as the collective of citizens may also bring a complaint, it's possible that that procedure would also be something that could replace, if you like, or complement interstate complaints. Although we have not seen these kind of massive group-based complaints being brought in the context where interstate cases had arisen or may arise. And then there are practical considerations of for example, awareness and legal culture and so on. But to then make the point that apart from the interstate complaints that we have seen, the very limited number of complaints before the African Court, I would just want to say that in the African Court protocol, actually, the relevant clause only talks of not the idea of an erga omnes or a public order form of interstate complaint or case being brought before the African Court. It only refers to the kind of diplomatic protection. It talks of the state being able to submit a case against another state on behalf of its citizens who are victims of violations of human rights. So that seems to be a very constrained clause within the African protocol, but even the case of the DRC that's before the court, I think has at least a dual nature. It may be viewed as a case that is brought on behalf of the citizens of the DRC alongside being brought in the collective interest of upholding the public order, so to say. But so to jump quickly to the advisory proceedings before the African Court, and I know the time is running, just to say that states are able to bring advisory requests, but so far no state has brought an advisory request. The requests that have been brought were mostly by NGOs, which have a limited standing before the African Court. And what I thought would be interesting just to see to what extent have states now become involved in these advisory requests before the African Court. In the setup case, which was very important because it had to establish under what conditions would NGOs actually be able to submit advisory opinion requests, we see that there were 7 states that actually intervened, which I think is a significant number. And these states were actually split on the answer to the question, with 2 states saying that NGOs are entitled and 2 states saying that they are not, and others then being, if you like, silent on the matter. In the end, the court adopted a relatively limited interpretation of this particular clause, which was even more limited than what at least 2 of the states advocated in their submissions. There was also an amicus brief in that case. If we look at another 3 cases, advisory opinions that had been handed down by the African Court, we see there is a limited number of states that take the invitation to submit to hand. We see in the case concerning the African Committee's jurisdiction, there were 4. In the vagrancy case, there was 1, and in the elections in times of COVID, there was none. So again, we see a relatively limited engagement, if you like, in the sense of being collectively involved in shaping not just what interest the state has individually, but these questions, the advisory questions, are obviously of interest to the system as a whole, and we see limited interest and capacity to deal with these so far. Then just to briefly talk about the contentious proceedings before the African Court as a means, if you like, almost to replace or to also allow for interstate or then these kinds of collective inspired complaints. We have this very important case of Morna, which is an individual bringing a case against 8 states because they were state parties to the African Court protocol that accepted the court's jurisdiction. That's why they are cited. But essentially, this case is about the Sahrawi Arab Democratic Republic, the people of the Sahrawi. So it should perhaps have been an interstate case, Sahrawi Arab Democratic Republic, which is a state party, against Morocco, because the case here concerns Morocco's admission into the African Union in the face of Morocco not recognizing the right of self-determination of the Sahrawi people. However, Morocco is not a state party to the African Charter or to the court protocol. Hence, an individual brought the case, and what we saw then is that Sahrawi Arab Democratic Republic was an intervener, is allowed as an intervening state to make these points about erga omnes obligations that the applicant made in the case, and that the state would have made itself if it had been the one to bring the case. And we unfortunately see only 1 other African state joining as an intervener in that case, that is Mauritius, with the Chagos history obviously also very much at the forefront of developing the right to self-determination. Then I thought lastly, just to maybe contrast the relatively limited engagement that we see in front of the African court with how African states engage with the international fora beyond Africa. We know that African states, had been quite reluctant to really fully engage with the international system, the issues around exclusion from the system and legitimacy. We see in the early years in 1971 in that advisory opinion around Southwest Africa, Namibia, we have 2 African states submitting written statements, and that was out of a total of 12, so relatively limited use by all. I count that as 5% of the OAU members at the time, and then the global total would be 9% of all states. So the African states were less engaged, if you like, compared to African states generally. The Western Sahara case, a few years later, more or less the same pattern, 2 states from Africa making written submissions from 12. Then if we look later on to the Chagos advisory request, we see 8 African states. That would be 14% of the African states now. So it's slightly up from where it was initially, but still quite low. And then the climate change, as with the international community, a higher level of engagement, 22% of the African states, according to the information I took from the ICJ website, had made written submissions compared to obviously almost a double that at the global level. And then just to bring us to 2024, we see in those 2 cases concerning the Palestinian territories that we have 20% of African states and 11% of African states. So clearly we see a relatively higher engagement, much as reference has also been made to South Africa versus Israel and the Gambia and Myanmar. So the question remains, to what extent is there a paradigm shift, as has been asked, in terms of how African states engage both internationally and globally? And does that shift, that shift that may be informed by geopolitical factors and domestic imperatives, how does that reflect back to the regional system? That the regional system seems still to be relatively underutilized, and I think one has to draw a distinction between the factors that inform African states' participation in international fora compared to, or perhaps juxtaposed against, how they perceive their own regional system as a forum for which this is a good outlet. So thank you very much for the opportunity. These are thoughts I hope that will just further inform our discussions and debate.
Thank you very much, Franz. That was really interesting. And last but not least, I'll pass it on to Jorge Contese, Professor of Law at Utrecht Law School, who will give us an insight into the Inter-American system. Thank you, Jorge.
No, thank you for the invitation. And I'm just sharing my screen to make it easier to follow the few thoughts that I want to refer to based on the contribution to the volume. So what I'll do is simply go straight to the practice. I'm going to skip everything that connects with the mechanisms or norms under the American Convention on human rights when it comes to interstate disputes, and just give a few thoughts on what the practice has been over the past decades, and connect this to the question, of course, of collective trends that we see in general international law, but particularly inter-American human rights law. So there are only 2 cases, 2 interstate disputes that have been brought before the Inter-American System of Human Rights, before the Inter-American Commission. In the Americas, in Latin America, there is a commission and a court. It is for the court to address interstate disputes. The first one in 2006, the second one in 2009. None of these cases were quote unquote successful. The first one, Nicaragua, challenging Costa Rica's immigration policies, was found inadmissible. The commission found that Nicaragua had failed to provide sufficient evidence. And the second one concerning the extrajudicial execution of an Ecuadorian national by the Colombian armed forces in a military operation that took place on the border between Ecuador and Colombia. The 2 states ultimately decided to finalize the case through a friendly settlement. And so there hasn't been any actual practice of interstate dispute in the inter-American human rights system. And what I do in my contribution and what I want to share with you in these few minutes is that Latin American states have instead resorted to the mechanism of advisory jurisdiction, advisory opinions, what I call a covert interstate dispute mechanism. So just like France was referring to the African system, what we see also in the Americas with some differences is that states resort to other mechanisms rather than the direct mechanism of an interstate dispute. And so what I'll simply do here, and of course I invite anyone who is interested in learning about this to consult the actual chapter, is that one could think, well, there are no interstate disputes then in Latin America or between Latin American countries. Well, that's just not true. So first, of course, there are human rights disputes, but there are also sort of non-human rights disputes. Anyone who is familiar with the ICJ docket will know many cases that are brought by Latin American states against other Latin American states concerning maritime disputes, an interoceanic canal, and other issues. And many of those ICJ cases have relevance to the more sort of narrow focus of human rights disputes that I'm interested in here. So many of this requests for advisory opinions that Latin American states make to the Inter-American Court, it's for the court, not the commission, for the court, of course, to render advisory opinions, are, in my view, really sort of an interstate dispute mechanism in guise, sort of a covert interstate dispute. So I'm just going to refer to a few of this to give you a sense of what's happening. So in 1997, Mexico requested an advisory opinion on the right to information on consular assistance. And what I do here, you'll see that there's plenty of quotation marks because it's really a case of Mexico versus the United States. The United States is not a party to the American Convention, and so the court has no jurisdiction over the United States, even though the United States is part of the Organization of American States, being a nation that is in the Americas. So what Mexico did, concerned with the situation of Mexican nationals being detained in the United States and not being given or their rights under the Vienna Convention on consular relations being infringed, Mexico requested an advisory opinion, which was really a sort of interstate dispute. In fact, the United States, again, not being subject to the jurisdiction of the court, made written submissions saying this is sort of a diagonal way of bringing me before the Inter-American Court, but you, the court, have no jurisdiction. Then again, Mexico did something similar in direct response to a US Supreme Court decision concerning the rights of undocumented migrants in 2002. Mexico reacted by requesting an advisory opinion before the Inter-American Court on the legal condition of and the rights of undocumented migrants. In this case, the United States did not participate at all. I think they had a bad experience with the previous case, and so they preferred not to appear before the court. And then again, in 2022, Mexico once again submits a request for an advisory opinion on the activities of private companies that are engaged in the firearms industry and their effects on human rights. This is, of course, a case, and Mexico says it explicitly in its request before the Inter-American Court. It talks about the situation between the United States and Mexico, how firearms coming from the United States into Mexico are responsible for the increase of killings in Mexico, And in this case, the United States once again participates. It understands that this is a case brought against the United States, sort of an interstate dispute, and it challenges the Inter-American Court's jurisdiction. It says you cannot issue an advisory opinion. This is something that pertains bilateral relations. I have not recognized your jurisdiction. And so it's another way of a state bringing an interstate dispute by this sort of diagonal way. And then two final cases, both of them requests for advisory opinions by Colombia, one against, once again, versus Nicaragua on the right to a healthy environment. Interestingly, there were several cases between these two parties, Colombia and Nicaragua, before the ICJ, while Colombia decided to make this request. So this is another interesting comparison to the African context in which the African Commission was saying we're not going to intervene because there are pending cases before the ICJ. The Inter-American Court has a utterly different approach. It says it doesn't matter that there's a pending case before the ICJ. We can still rule on these issues. And then the last one, but there are other cases. These are the ones that I canvassed on my contribution, Colombia versus Venezuela in 2020, on what are the human rights obligations of states that have denounced the American Convention. This is really a question concerning Venezuela because Venezuela pulled out of the system. So once again, this is my main contribution. It's really looking at this request for advisory opinions, which are in reality covert ways of bringing interstate disputes. So three final remarks as my time is up. Well, we've been talking a lot about the use of advisory jurisdiction. A few years ago, I published an article in the American Journal of International Law in which I call this trend a rule of advice, meaning one can think of advisory opinions as doing either two things. One is to anticipate adjudication, and so to provide guidelines to states and others of how a particular international tribunal understands a legal question. But also what we see here is international tribunals, or at least Inter-American Court of Human Rights, actually ruling through advice, using its advisory powers to render rulings that it otherwise could not do under the contentious proceedings. Another point is the use of the Inter-American Public Order Standard, which is once again this collective trend of states partnering and teaming up around obligations that they believe to be erga omnes, and so giving them standing, a little bit of what Professor Angelet was talking about at the beginning of this session. It's not just a question of dispute settlement, but it's really a question of how to protect the general order by way of using these mechanisms. And finally, also a comment that was made at the beginning, when we think of the international tribunals, and in this case, the ICJ, as some form of global constitutional forum. I'll stop here to give time for questions and comments. Thank you again.
Thank you very much, Jorge, and thank you all for staying with us. I know we've gone a bit over time, but I hope you'll agree with me that it was all worth every word and every intervention. So over to you, Jean-Pierre, for a few questions. I think we'll for some.
So we have a few questions that came in online, but I'll give precedence to the room in terms of questions. So we have one question over there and one question at the back. So yeah.
Yeah, but
if you could introduce yourself.
Okay, so I'm my name is Ali. I've actually worked with Dr. Garciandia with some of her research on this topic, and my question is sort of open to any of this panel, and it's sort of following on from what Professor Contesi was saying and what we actually opened with about. It's mainly focused on the ICJ, and it's a bit long-winded, but it'll make more sense as I ask it, I think. So just to sort of give a preface that, when we look at Ukraine v. Russia and the sort of interventions that states, the declarations of intervention under Article 63, that sort of is interesting. Perhaps, I mean, this is just to speculate, maybe Article 63 was chosen perhaps because of the success by New Zealand in the whaling case from 2013. So maybe that's why states may have sort of opted to pursue under Article 63. But what's interesting, that's the development that's happened in Ukraine v. Russia since then, and also I think in the South Africa case, is intervention under Article 62 with this interest of a legal nature being connected to this notion of obligations erga omnes, and that sort of connects to another debate more broadly about whether one can initiate a case on the basis of erga omnes, and that's still an open question because thus far the cases have been with erga omnes partes. And what's interesting is, depending on how the court sort of responds to those interventions under Article 62 relating to erga omnes, sort of connecting that to initiating a case on the basis of erga omnes, could that potentially be quite useful for human rights litigation at the ICJ and perhaps international law more generally? Because if we recall sort of the Barcelona Traction diction, that sort of human rights obligations are also counted as part of erga omnes, could this sort of open the door for human rights litigation outside of more specific contexts of genocide and torture under the concept of just obligations erga omnes, no partes, and obviously assuming you have jurisdiction established? A complicated question, I know, sorry.
Maybe should we collect a few?
Thank you very much. Yeah, I think we'll collect a few different questions and then we'll have one round of answers because I'm conscious of time. I think you had your hand up. Yeah.
Hi, I'm Victor, happen to be visiting London. My question is slightly more general one, is on are we or should we be worried that the trend towards collectivity will open a Pandora box that the sovereign voices, in particular of the smaller states, will be bought and sold in open diplomatic market, in particular by the larger states who would like to shape global narratives through courts?
Thank you very much. Any other questions in the room? And if not, I'm going to read a couple of questions that came in online. One question Meryl has kindly already responded to. One question, David, is directed at you, which is, if the ICJ and CERD have directly conflicting interpretations of a national origin, is the CERD not obliged to follow the ICJ interpretation? Another question is a bit more general, which is, almost all state parties are parties to the Convention on the Rights of the Child. What can be done for better protection of children's rights, given the current genocides and war crimes against children taking place around the world? There's a question by Aitan, which is, I think, more directly related to Margaretha's presentation. I'll raise it just in case, but Margaretha has also offered to address questions in writing, which is how are coalitions formed in the context of, for example, climate litigation in terms of bringing states together? Are there frameworks that countries have adopted to frame climate impacts together and prevent overly broad or general rulings? So I think that's it for all of the questions. Shall we go in the same order that we went throughout? So over to you. I don't think we actually.
Yeah, no, you
Okay,
know
yeah.
the mic.
Now, thank you for all these questions. I will, since I'm the first one, I can choose. So perhaps I would like to address your questions on whether small states and their role in proceedings will be sold on a diplomatic market. That was your question, right? It reminds me of that notion that was invented by the World Bank a few decades ago of state capture. That was after the collapse of the Soviet Union, where elites tend to control states in their own interest. I see a risk in that respect with collective proceedings. I'm not so sure that small states would be for sale on a global diplomatic market, but what one does see is that when they cooperate, as they certainly should do, you see many lawyers popping up in the proceedings arguing, or the same law firms arguing for one state, and then popping up again, arguing for another state. All these people are extremely qualified. Of course, that is probably part of the coordination, and yet it makes me feel a bit unhappy, because it gives the impression that if we are looking for quantity, and if every sovereign state is supposed to be there because they are sovereign states, in fact, they are used as devices by law firms who probably represent a different interest, which is not quite clear. So I think that it is an issue. It is an issue. That's all I can say. Perfect. With all due respect for those brilliant lawyers who do that, I'm sure them didn't make me very popular.
Thank you very much. I think Veronica was next.
Yeah. Yes, I would also like to choose among all questions, and I would like to pick the question from Vadim Aknash regarding the Convention on the Rights of the Child. It's actually a great question because we have not delved into this convention, but it has an interstate procedure which is internally managed from the Committee for the Protection of the Rights of the Child. The procedure is contained, if I'm not mistaken, in Article 12 of the optional protocol dedicated to the resolution of disputes and to the reception of individual and interstate communication. But we have a double problem here, insofar as to launch this interstate procedure, of course, the interested state should have ratified this protocol, and this procedure is also subject to reciprocity. That is, the applicant state and the recipient state should have opted in the procedure. Plus, if I'm not mistaken, again, the optional protocol dedicated to this procedure has been ratified by more than 50 states among all the state parties to the Convention on the Rights of the Child. So it's still a viable option, but of course one should check which states have ratified the protocol, plus which states have accepted the interstate procedure in it, which is like a standard UN committee procedure, also subject to confidentiality of the session. Still, in order to tackle this problem and in order to identify what can be done for the better protection of these rights, of course, the enforcement of the Genocide Convention before the ICJ is the viable option, and we saw and discussed the rise of interstate litigation based on the Genocide Convention. It's open to directly affected states, non-directly affected states, but of course, like with all genocide cases here, the evidentiary standards are high. So let's see if this trend of collective litigation touch upon the genocide as an instrument for protecting the rights of the child. And let's hope also the Convention on the Rights of the Child to be finally enforced.
Thank you very much, Veronica, Meryl, and then Iran.
Thanks. I think I'm just going to continue with the same question, answering the same question as Veronica, just to note that this is, of course, the everlasting dilemma with many international law protections. How do you ensure their enforcement? Which also links to the answer to the question about the ICJ that I answered in writing, which is whether or not you think the ICJ is a useful forum in light of a world of nuclear weapons is usually going to be a matter of opinion and what you consider to be useful. But just to go back to the Convention of the Rights of the Child, so there are, Veronica's talked about some of the interstate mechanisms, but there are, of course, many other mechanisms that we always use when we're trying to enforce human rights. So there are individual complaints where there's jurisdiction. Veronica's already spoken about the fact that there has to be agreement of the states for those complaints to be deposited. There are other mandate holders. There are, if you are within the scope of a regional court and a regional convention, perhaps you can use those conventions as well, where the rights of children intersect. And there's always sort of NGO pressure campaigns everywhere. There's multiple different mechanisms that when you're trying to uphold human rights, you're going to look at, especially when it comes to children. And this is what, when you're thinking about a strategic litigation campaign, you're going to be thinking about all of the mechanisms at your disposal. Can you coordinate them? Will they work together? Will they detract? And what can be done? And then if you get a decision in your favor, let's say there's an individual complaint and you have a decision in your favor, how are you actually going to enforce that in the state? How are you going to make the legislative change or the policy change? How are you going to ensure that there's sort of follow through on that? And these are some of the big questions that have been raised in the topic today about how do you actually make these mechanisms useful?
Thank you very much, Meryl. Aaron?
Thank you. I'll just touch on a couple of points. One on this idea of litigation and the marketplace for small states. I don't know, as Nicolas said, if that will happen per se, but the choice of litigating or not litigating, as I mentioned before, is a political one that involves a lot of consideration, including costs and policies and interests, and of course, the power dynamics between countries. So if you look at Nicaragua's intervention in South Africa v. Israel, which they pulled, quoting the costs of intervention, I think Nicaragua was well aware how much this would cost when it filed it, has a lot of experience at the court, but the politics may have changed. And we'll see also what happens with the Nicaragua v. Germany case. So you see there are different considerations and shifting politics and possibly costs at play. I think one of the dangers of the quantitative element, perhaps, of this litigation, coordinated or collective litigation, is something that one of the ambassadors in New York of one of the participating states in the climate change proceedings told me during one of the hearings. He said, well, this is just like the General Assembly, only a little more organized. And I think there's a danger. There's, of course, a relevance and importance to know how many states are in what corner on a given legal issue. But there is a danger that it will just become a repetition of their political views in a legal format. And finally, I think it would just be good of me, perhaps not wise, to join Nicolas in saying that I too think that litigators' counsel should not appear for more than one party in a given litigation. So I also will be unpopular. Thank you.
Thank you very much. David?
Thanks. Yeah, I'll answer the specific question. Is CERD obliged to follow the ICJ? In a word, no. I don't see in the text of CERD where such a hierarchy will be established, or such a sort of where the treaty body is required to follow the ICJ. So I don't see it in the text, and it's not in the practice of the committee, because the ICJ judgment came out in Qatar versus United Arab Emirates. After that, Qatar discontinued the case due to a diplomatic agreement that was reached, but the committee remained seized of the matter for a year following Qatar's discontinuation. So the committee said there was an ad hoc conciliation commission formed, interestingly formed of both CERD members and non-CERD members, including a former ICJ judge, but it never completed its task because Qatar discontinued the case. But the committee remained seized of the matter for a year until the final discontinuation. So in the practice of the committee, it didn't drop the case because of the ICJ.
Thank you very much. Franz, and then Jorge.
Thank you very much. Very interesting discussion. I think there wasn't a specific question, but just on the issue of cost, I think the economics of these processes are perhaps to be foregrounded. I mean, the involvement of these smaller states in Africa, for example, would be constrained often by these kind of pragmatic concerns. And I was just thinking about the role of the intergovernmental organizations, maybe at the sub-regional or the regional level. We see also in terms of the African continent, that in the most recent advisory opinions, the African Union has also brought written statements or submissions. And I think that is an avenue. If the regional organizations could be very deliberate about this, inclusive, create participatory processes, it could obviate the need for so many individual states to go individually, because their voices could be captured, if it would be possible, by this regional outlet, just maybe as a thought. But that is seemingly also happening in Africa already. Thanks.
Thank you, Franz. And Jorge?
Thank you, Jean-Pierre. Just two quick comments. One is to reiterate what Veronica was referring to in terms of the Convention on the Rights of the Child. I'm trying not to wear my Committee Against Torture hat here, but of course, David has referred to the ICERD, and I think treaty bodies are a prominent forum to bring those complaints, those cases, and to sort of to bring that narrative away from some of the usual mechanisms into these human rights procedures. And then the final point that I want to touch upon is what Meryl wrote as a response to the question on ICJ judgments not being binding. And I just want to add to this. Nicolas started mentioning the Chagos opinion from 2019. I think it's interesting to see how that opinion connects with something that I was referring to as the ICJ being sort of a human rights tribunal. It's a case of self-determination. And it's a case that, interestingly, 2 years after the ICJ rendered its opinion, ITLOS took that decision, that opinion, and talked about, quote, as having legal effect. That's a very relevant development. And then what we see is the UK sitting down with Mauritius and negotiating and trying to reach an agreement on what's going to happen with the Chagos Archipelago, with the military bases. And so the notion that ICJ judgments are simply not binding because they're advisory opinions, I want to sort of push back and take a different look and see how those opinions, and of course the judgments, but the opinions can be used by different actors in different proceedings to give them political and certainly diplomatic weight. Thank you.
Perfect. Thank you very much, Jorge. I think it's time for us to wrap up this event, and thank you very much for everyone for bearing with us in going slightly over time. Just before we do that, I did want to say a number of thank yous, especially as relates to the event today. To all our speakers, thank you so much for the generosity of your time and ideas in the event today. With regards to the book, I did want to say a massive thank you to BIICL for publishing, represented here by Lauren and Akiko, and to all the authors, some of whom are present today. And more importantly, on a personal level, to Rosana, for both coming up with the idea and for pushing this project forward over the last 3 years. So thank you very much for that. Final round of thanks to the events team for managing the event today. Liam, who you're seeing in the room, and who is behind the logo on the screens, as well as Carmel and Bradley for taking care of registrations. With that being said, the final word of thanks is to you all for your questions, for your engagement. And I hope that at least for the people in the room, that engagement will continue over drinks. I was told that there is someone who registered who might be under the age of 18. So I do have to make an announcement that if you are under the age of 18, you are not allowed to drink any alcohol. However, there are soft drinks available for anyone who is under the age of 18, or for anyone, and there is wine available for people to continue the conversation for anyone over the age of 18. Thank you very much, everyone.
Thank you.
Thank you. Bye.
Thank you. Bye-bye.
Thank you very much to our online speakers.
Thank you all.
Thank you.
Bye.
Thank you, everyone.